Okay, let's get into Chapter 3, Marriage and Emerging Alternatives. After reading this chapter, you should be able to explain how and why the concept of family has evolved over the past 50 years, distinguish among different types of marriages, identify ways in which the states regulate and restrict the fundamental right to marry, identify common requirements for valid ceremonial and common law marriages, identify and describe legal statuses accorded to same-sex couples in various states, including domestic partnerships and civil unions, distinguish among the rights and benefits that flow from traditional marriage, same-sex marriage, civil unions, and domestic partnerships. You should also be able to describe the potential role of a paralegal in cases involving marriage and alternative family relationships. So first, explain how and why the concept of family has evolved over the past 50 years. More than half of all first marriages end in divorce. The nuclear family is no longer the majority family model. The roles of men and women are less highly gendered. There is an increased social acceptance of alternative lifestyles and living arrangements. Cohabitation is no longer viewed by most as living in sin. Many states have granted legal recognition of some kind to same-sex couples, same-sex marriage, civil unions, domestic partnerships, etc. The women's rights movement is one of the primary reasons why the concept of family has evolved. The men's rights movement, the gay rights movement, fathers' rights movement. There's a decreased focus on marriage as a defining life event, especially for women. And there are greater legal protections of the right to privacy and sexual conduct between consenting adults. Distinguish among different types of marriages. So there's a ceremonial marriage available in all states, customarily requires a license and solemnization in a ceremony performed by an authorized person. A covenant marriage, a ceremonial marriage available in a small number of states that emphasizes the permanence of marriage. A common law marriage, available in a minority of states, a marriage created by the conduct of the parties rather than in a formal ceremony. It used to be that Ohio recognized common law marriage. They no longer recognize the institution of common law marriage. Same-sex marriage, a ceremonial marriage of two same-sex partners available in a limited number of states. A putative marriage, recognized by courts in some states, a presumed marriage of a person who has cohabited with another in the good faith belief he or she was legally married to the person. So again, this is similar to the putative spouse concept from Chapter 2. Identify ways in which the states regulate and restrict the fundamental right to marry. The U.S. Supreme Court has definitively established that the right to marry is a fundamental right that cannot be restricted absent a compelling state interest. This was the case of Loving v. Virginia, which just celebrated its anniversary. I think it was last week, actually. So this is a case that you may have heard of. It's been in the news recently. The right to marry is not absolute, and the states are permitted to regulate it to a reasonable extent. Impermissible restrictions include restricting the right on the basis of race, delinquency in child support payments, or incarceration in some circumstances. Loving v. Virginia dealt with restriction on the basis of race, and that was struck down in the Loving v. Virginia case. But again, it wasn't until that case that parties of different races could marry in the state of Virginia. So it is recent vintage in the grand scheme of our constitutional law. So marriage is a contract between the spouses regulated by the government. There are basically two types of requirements that are fairly standard state to state. Requirements relating to legal capacity to marry and technical requirements governing particular types of marriage. The sex of the parties, only a limited number of states permit parties of the same sex to marry. Age of the parties, under common law, 12 for females, 14 for males. Now it's 18 in most states without parental consent, and the requirement must be waived in some circumstances. May be waived in certain circumstances. Marital status of the parties, neither party can be married to another person still living at the time of the marriage. Some states allow the impediment to be removed by death or divorce. Degree of relationship between the parties by blood, also known as consanguinity. Degree of relationship between the parties by marriage or affinity. Mental capacity of the parties. The parties must be able to understand the nature, duties, and responsibilities of marriage. Physical capacity of the parties. In a limited number of states, they must be free of syphilis, for example. And that's not really as silly as it might sound. I was recently listening to NPR, and this is not in the US, but, and I wish I could remember what country they were referring to. I can't right offhand, but if anybody's interested, send me a note and I'll try to find it. But they are considering requiring sickle cell testing before they will permit parties to marry because of the spread of sickle cell disease. And so I thought that was really interesting that, it seems like a silly concept, but it's still happening around the world. So something to consider. Identify common requirements for valid ceremonial and common law marriages. Common technical requirements for a valid ceremonial marriage include application for a license, a medical certificate in a limited number of states, the actual license. There's usually a waiting period of 72 hours, may be waived in some circumstances. Typically, a case in point would be like Las Vegas marriages. But yeah, that's typically there are certain circumstances under which they will waive that 72-hour waiting period. Ceremony must be conducted by a person authorized under state law, which is why you will hear during the ceremony by the power vested in me by the state of Ohio, for example. Recording of the marriage license or certificate of marriage. Common requirements for a valid common law marriage. Again, the common law is the we've reviewed. It's going to be different from the ceremonial marriage, again recognized in a minority, I would say, of states. You must have legal capacity to marry, must simultaneously agree to be married. The parties must cohabit, though consummation may not be required. The parties must hold themselves out to the public as husband and wife. There is no requirement that the parties live together for a specific length of time in any case, in the case, except in the case of New Hampshire, where there's a 3-year requirement and common law marital status is only applicable in the context of inheritance and death benefit claims. Again, Ohio does not recognize common law marriage anymore. They used to, but it's no longer applicable in the state of Ohio, which a lot of people are not familiar with. They come in and we've got people who are long-term relationships that would have still been recognized in the earlier years of their relationship as having been common law. However, now that the law has evolved and they have removed the common law marriage in the state of Ohio, some people are still a little surprised that they are no longer considered to be common law spouses. Identify and describe legal status as accorded same-sex couples in various states, including domestic partnerships and civil unions. Same-sex marriage is available in a limited number of states. Adult adoption, available in a limited number of states as a means of creating a, quote, family relationship, which would give rise to inheritance benefits, would give rise to insurance benefits, also to access to health care records, those types of things. Functional family status, applied by some courts to extend limited benefits to same-sex partners who are in committed long-term intimate relationships, support each other emotionally and financially, share roles, and hold themselves out to others as spouses. Domestic partnership, available in a minority of states, it has been defined as a status granted to an unmarried couple who live together and receive a variety of economic and non-economic benefits customarily granted to spouses. To enter a domestic partnership, the parties typically must be at least 18, not be a party to any other legally recognized status, or be related in any way that would prevent them from legally marrying, share a residence and be in an exclusive relationship, agree to be responsible for each other's living expenses, and agree to file a certificate of dissolution if their relationship ends. In some states, the status is extended to heterosexual couples as well. Civil unions, available in a minority of states. Civil unions are essentially designed to afford same-sex partners the same benefits, protections, and responsibilities that married heterosexual spouses have under state law. To enter a civil union, the parties typically must be of the same sex, be at least 18 and mentally competent, and not be a party to any other legally recognized status or related in any way that would prevent them from legally marrying. To terminate their relationship in a state that recognizes civil unions, they essentially use the same procedure as used in a dissolution of a traditional marriage. Distinguish among the rights and benefits that flow from traditional marriage, same-sex marriage, civil unions, and domestic partnerships. According to a report of the U.S. General Accounting Office, there are more than 1,000 rights and duties that flow from traditional marriage, including, for example, the right to receive support from a spouse, the right to seek a division of marital property upon divorce, absent an agreement to the contrary. Absent an agreement, the rights and benefits that flow from a traditional marriage are the right to inherit from a spouse and to receive certain governmental benefits such as Social Security and veterans benefits provided applicable conditions are met, the right to continue employer-provided health insurance for a specified period under COBRA, the right to make medical decisions for a spouse, the right to file a claim for wrongful death of a spouse, the right to exercise the marital communications privilege. What are the benefits that flow from same-sex marriage? In states that recognize same-sex marriage, as of the summer of 2012, same-sex spouses are entitled only to benefits available to spouses under state law. The Federal Defense of Marriage Act, otherwise known as DOMA, passed in 1996, still in force in the summer of 2012, but being challenged and continues to be challenged today, but does not declare same-sex marriage illegal, but does define marriage for all federal purposes as the legal union of one man and one woman as husband and wife. The federal DOMA also provides that no state can be forced to recognize same-sex marriage in response to a majority of the states a majority of the states have passed many DOMAs in the form of statutes or constitutional amendments effectively denying to same-sex couples the rights and privileges guaranteed to heterosexual married couples. Again, the law has changed since the publication of your textbook, obviously. So some of these things are the current administration, I'm going to say it as delicately as I can, is seeking to get back to some of the more DOMA-minded policies. But as of right now, same-sex marriage is legalized and permissible, and the same-sex partners are given the same benefits essentially as heterosexual married couples, are given the same protections as heterosexual married couples. But again, under the current administration, it's sort of a stay tuned to see what happens sort of thing. There's no standard set of domestic partnership benefits. They vary by state where such partnerships are recognized and are usually less extensive in nature and extent than benefits extended to partners in civil unions. The rights, benefits, and obligations of partners in civil unions are essentially the same as those of heterosexual spouses under state law. So the potential role of a paralegal in cases involving marriage and alternative family relationships. The paralegal's role will vary depending on the nature of the case, the prevailing law in the jurisdiction, and the extent to which the employer's practice addresses issues involving same-sex relationships. In cases involving a traditional marriage, the paralegal might be assigned to obtain copies of the marriage license and any necessary supporting documents or translations. In a case involving a potential annulment, the paralegal may draft documents, research governing law, prepare discovery requests for review, etc. In cases in which common law marriage is claimed, the paralegal may gather information, affidavits, and documents needed to support the client's position. Take a look at application 3.4 on page 80 of your text for information gathering in a common law marriage case. However, remember that it's not recognized in the state of Ohio. Because this is a cutting-edge and rapidly evolving area of the law at the heart of a very heated debate, thorough research is a key task performed by the paralegal. Thorough research and review of research and update of research are all very important. Again, so that is chapter 3. Remember, like I said, this is an older textbook, so the DOMA laws obviously have changed, and same-sex marriage laws have changed as well. But again, it's sort of a stay tuned because we don't know what the current administration is going to do or attempt to do with restricting the rights of same-sex couples to marry and be given those legal protections. So that is chapter 3. I will post subsequent videos for chapters 4 and 5. And if you have any questions, feel free to email me or post them in the discussion board. Have a good day.